morning. This is Ron and Gloria Mickens, and I'm going to give you a story that you will never forget. This story is about our experience with fraud upon the court over the last 22 years. Fraud upon the court. And I'm going to get right into it. I'm going to start out by giving you a legal definition of what fraud upon the court is or entails. Fraud upon the court is a criminal act whereby the court is impaired in its impartial performance of its task. In the U.S., fraud upon the court is usually done by an officer of the court. Fraud upon the court embraces only that species of fraud which does or attempts to defiles the court itself, or is a fraud perpetrated by officers of the court so that the judicial machinery cannot perform in the usual manner its impartial task of adjudging cases that are presented for adjudication. That is a legal definition of fraud upon the court. And I have the burden to prove to you that judges from the 10th Judicial Circuit, the 2nd District Court of Appeal, the Federal District Court in Tampa, and the 11th Circuit Court of Appeal in Atlanta have committed fraud upon the court. And their impartiality was bought by this company, Stewart Information Service Corporation. A little bit about Stewart Information Service Corporation. It is a customer-driven, technology-enabled, and strategically competitive real estate, information, title insurance, and transaction management company. Wholly owned management company. Wholly owned subsidiary, Stewart Title Guaranty Company, and Stewart Title Company. Offers products and services in the U.S. and abroad through its direct retail operations, independent agencies, and the Stewart Trusted Provider Network, and other companies within the Stewart family. Stewart Title is headquartered in Houston, Texas, United States, and has approximately 6,350 employees. The company was founded by Marco Stewart in 1893 in Galveston, Texas. The company has grown to offer title insurance policies and escrow services in more than 80 countries. Now, what I am alleging, and you're going to be the judge, that this company paid money to purchase injustice. They call it blood money, but they bought justice. They bought the judges, the opposing lawyer, including my own lawyer, off. So you got to stay with me because you don't want to miss it. You don't want to miss this. Damron Construction Company was hired by Ron and Gloria Mickens, that's us, to construct us a custom home. We owned our own real property or / land. We owned it clear and free. Unbeknownst to us, Damron went to Stewart Title of Polk, Stewart Title Guaranty Company, and they conspired and agreed to fraudulently create, make, prepare, execute, notarize, deliver, record a quitclaim deed to our real property without our knowledge or consent. Let me say that again. They created this deed, this quitclaim deed to our property without our knowledge or consent. We didn't know anything about this purported transfer or conveyance of our real property to Damron Construction Company. As time went on, we started having all kinds of problems with Ellen and Debra Damron Construction Company. It came to the point to where Ellen Damron said that we would be the last people on earth that he would sell his house to. So after investigating, we finally found an attorney who told us that there had been a quitclaim deed filed in the county records by Ellen Damron Construction Company. So what he did, he wrote an affidavit of equitable owners and told us to go to the courthouse and file it into the county records. So that's what we did. We did that to stop and to prevent Ellen Damron from selling our property. He was marketing the property to other customers or to other buyers. As time went on, Ellen Damron Construction Company initiated a lawsuit against us. They filed a 3-count lawsuit against us predicated on that fraudulent quitclaim deed. We countersued. We filed our defense, our affirmative defenses, and we countersued with a claim for fraud, for cancellation of the deed, quiet title, ejectment, and breach of construction contract. So we went to trial. I have a copy in front of me here. Judge J. Tim Strickland's findings of facts on the merits of our Ron and Gloria Mickens 5 claims: fraud, cancellation of the deed, quiet title, ejectment, and breach of construction contract. Judge Strickland stated that Damron Construction, through the person of Ellen Damron, failed to execute the above referenced deed in the presence of 2 witnesses as required by Section 689.01 Florida statute. Damron Construction's actions and misrepresentations constitute fraud in the execution of the quitclaim deed. He stated, based on the above findings, it is hereby ordered and adjudged that the quitclaim deed is void ab initio. That meant that the quitclaim deed was voided from the beginning. It never existed. It never was any good. Not then, not ever. It was void. annulled. So that left a house on our real property. We were entitled to this house because we had won it by windfall, because of Damron Construction Company, Alan and Debra Damron's fraud. Judge Strickland determined that Damron committed fraud by misrepresenting the nature of a quitclaim deed, fraud, inducement, fraud in execution of the deed, and fraud in the formation and performance of the construction contract. Judge Strickland stated that Damron Construction Company breached the construction contract by failing to perform work of good quality, free from faults and defects. Failing to submit change orders in writing as required by the contract. Failing to have change orders approved by the Mickens as required by the contract. Failing to close the loan commitment with the Mickens Bank, Nation Bank, and thereby depriving the Mickens of a VA-protected construction loan. Failed to pay all subcontractors as required by the contract. Judge Strickland also stated that, therefore, ordered and adjudged that the Mickens claims, including fees and costs, is granted. And that sounds good so far, in our favor. So that our claims for damages, fees, and costs were granted. Anytime you sue for fraud, the remedy is money. We amended our complaint to specifically name the amount of damages. We asked for $3,906,000 in compensatory damages and $7 million in punitive damages. Remember, the judge said that the Mickens claims for damages, fees, and costs was granted. So we prevailed on our cancellation of deed claim and cause of action. So therefore, we won by windfall the house because of Damron's Construction Company's fraud. But Judge Strickland said that this was not the way this trial was going to be resolved. He wanted Ron and Gloria Mickens to permit Damron Construction Company or some other claimant, meaning Stewart Title Guaranty Company, to purchase us a lot for no less than $60,000 in a location we pretty much chose. But in exchange, he wanted Ron and Gloria Mickens to transfer or deed over the lot and house to Damron Construction Company or some other claimant, and he wanted us to hold Damron Construction Company harmless and release them from their liabilities and responsibilities for their crimes and torts, and say that the $60,000 lot was satisfaction for all of our claims for damages, fees, and costs. Now, I hope you understood that. Let me repeat that again so it's clear. We, Ron and Gloria Mickens, were supposed to accept a $60,000 lot, vacant lot, in exchange for signing over our land and the house, deeded it over to Damron Construction Company or Stewart Title Guaranty Company. And we were going to accept, or the judge wanted us to accept, the $60,000 lot as satisfaction for all of our claims for damages, fees, and costs. Now, I just told you that we had prevailed on our fraud claim, our ejectment claim, our breach of construction contract claims. We specifically stated the amount of damages in which we were entitled to. Now, who in their right mind would accept an agreement like Judge Strickland's own personal, unique judgment remedy? Didn't have anything to do with the record or the pleadings. The evidence wasn't requested by us. He just pulled his judgment/remedy out of the sky instead of giving us a judgment on the merits of our fraud, cancellation of deed, quiet title, ejectment, and breach of contract actions. This was done without jurisdiction, or being imposed without jurisdiction. This is fraud upon the court. But let me go on, because it's gonna get a little bit more exciting, exhilarating than this. At this point, we thought this judge had to be kidding, because you remember, Damron couldn't commit this fraud by himself. He conspired with Stewart Title Guaranty Company, Stewart Title of Polk, Elaine P. Canady, Edith F. Rewis, and Carey Harman-Highsmith. Especially Miss Elaine P. Canady, because Miss Elaine P. Canady was a title insurance agent. She was the issuing agent. She was the notary. And she was the closing agent. Okay? This lady was in control of everything. She was responsible for doing a title search. She was the notary public who false notarized the document on behalf of Damron. She was a witness. She fraudulently witnessed this document, this quitclaim deed, along with Mrs. Rewis. So, Stewart Title Guaranty Company, Stewart Title of Polk, Canady, Rewis, Damron Construction Company, Carey, Harman-Highsmith, they all conspired to fraudulently convey our property, to fraudulently convert our title, to slander our title, to fraudulently induce, chase, to fraudulently issue a title policy, to fraudulently encumber our property with the mortgage. Now, the main point that I want to point out to you, we had prevailed on those 5 claims, but we're going to, and we did in 2 other lawsuits, but they were ignored. we were going to add Stewart Title Guaranty Company, Stewart Title of Polk, Elaine P. Canady, Edith Faye Rewis, Carey, Harman-Highsmith. They were indispensable parties to this action. They should have been a part of the lawsuit from the beginning. So we were going to join these parties. And here's a list of the additional claims that we were going to be entitled to, and we were going to prevail because of their conspiracy and their fraud. Basically, what I'm saying is, when we got a judgment on the merits against Damron Construction Company, we also was getting a judgment against Stewart Title Guaranty Company, Stewart Title of Polk, Canady, Rewis, and Highsmith for fraud also. So let me just go down this list of claims that we were entitled to against Damron Construction Company, Debra Damron, and Damron, and their co-conspirators. Malicious prosecution against Damron and Stuart Title, false acknowledgement, failure to validate signatures, commission of prohibited acts, malfeasance and misfeasance, fraudulent conveyance of property, fraudulent conversion of property, slander of title, civil theft, fraud, negligence, conspiracy, equitable estoppel, malicious misuse and abuse of process, negligent infliction of emotional distress, defamation / stigmatization. So we had all these claims coming against Damron Construction Company conspirators. Now, our damages is going to go from approximately $11 million to $100 million. Okay? So this cover-up had began earlier. This cover-up had began by the Polk County State Attorney when we pulled a copy of that quitclaim deed in the county office, myself in particular. It was my first day in Bartow, Florida, at the county courthouse. I obtained a copy of the quitclaim deed. Once I saw it, and I saw these strange people name on the deed, I saw the notary stamp, I saw the witness, so I rushed up to the state attorney's office and asked them, requested, demanded that they do an investigation. So the state attorney sent one of his investigators over, and make a long story short, Miss Canady confessed to fraudulently notarizing and fraudulently witnessing the deed. But when I read the investigative report, I detected a cover-up. They was leading her in the interview, like they was coaching her on what to say and what not to say. They was trying to relegate her conduct to being like it was just a mistake, or it was like a happenstance, an accident. No, it was no accident. Miss Canady committed the most egregious and unconscionable crimes that can be committed by a title agent, by an issuing agent, by a notary public, by a closing agent. Miss Canady wore all of those hats. Damron couldn't possibly have defrauded our property without her egregious act. I never heard of them closing on our property, and we didn't know anything at all about it. Where's the documentation when you go to a closing? Where's all the supporting document? I don't even know where they are today. When I tried to obtain them, state attorney's office told me that they had burned them up. Okay. But what we detected was the state attorney trying to, omit these egregious acts, these fraudulent acts, these unconscionable acts. Said Miss Canady just took a false acknowledgement. There's no harm done. This is the way he summed it up. But we went, got a judgment now against Damron Construction Company. The state attorney had took this initiative to cover up Mrs. Canady, Stewart Title Guaranty Company, Stewart Title of Polk, Rewis, Highsmith. They're criminal and tortillas act. Those folks was involved in all kind of organized fraud, schemes to defraud, forgery, extortion. Or I have a list of some of the criminal and tortillas misconduct that they were involved in. I already mentioned some of these. False notarization, false acknowledgement, malfeasance, misfeasance, real estate fraud, bank fraud, wire fraud, fraudulent evictions, fraudulent ejectment, fraudulent conveyance, fraudulent conversion, slander of title, forgery, perjury, theft, defamation, malicious prosecution, abusive process, so on and so forth. So let's just go on and on. This was a cover-up. So when Judge Strickland was trying to impose his own personal, unique remedy, can't you see the cover-up? He was trying to extricate Elaine Damron, Debra Damron, Damron Construction Company, Rewis, Canady, Highsmith, Stewart Title of Polk, Stewart Title Guaranty Company from their liabilities and responsibilities for their crimes and their torts. So, the only thing that we could do at this time was to file an appeal. And both parties file an appeal of this action. And to make a long story short, the Second District Court of Appeal was obligated to reverse Judge Strickland's own personal, unique judgment / remedy about the $60,000 lot. They reversed because the relief that he provided was unsupported by the pleadings, unsupported by the evidence, unsupported by the record, objected to by both parties. He just pulled it out of the sky. He just circumvented giving us a final judgment on the merits of our 5 claims in which we prevailed on. Okay. Go back down or remand back down to Judge Strickland. He still failed to give us a final judgment. And the way he circumvented it is that he used recusal or disqualification as a pretext to avoid doing his lawful duty, entering or rendering a judgment on our fraud, cancellation of deed, quiet title, ejectment, and breach of contract claims and causes of action. he was unsuccessful in his attempt to extricate the Damrons and the Damrons co-conspirators from liabilities and responsibilities for their crimes and torts. Okay? He tried, and I look at it this way. This is an attempt to steal our money. He's trying to rescue Cisco, Stewart Information Service Corporation. When a judge commits fraud on the court, he get paid this blood money. He call it the blood money. When he deprive us of our life liberty without due process, trying to impose this remedy. His goal is to collect the blood money. When Jerry Hill, the state attorney, is ignoring, omitting, annulling, vacating, dismissing Miss Canady's Rewis and Stewart Title Guaranty Companies, the Damrons and fraud, covering it up. He's part of the conspiracy of collecting the blood money by depriving us. Oh, he said he was not a racist, but he sure was doing everything to see that we didn't collect anything for the wrongs that we had been subject to. Okay? Now, we see this fraud by Judge Strickland disqualifies himself. So the next judge comes in. Her name was Judge Cecilia M. Moore. Now, if you think what Judge Strickland did was egregious, you hadn't seen nothing yet. You gotta hang in there with me, because what Judge Moore did was egregious, unconscionable, and the most mental violent crime that I had ever seen in my lifetime. And let me get right into it and show you what she did. This is her order. She asked both parties to submit a motion for final judgment. Naturally, we submitted our amended complaint that Judge Strickland was required to give us the final judgment on our counterclaim. I'm looking for it. But anyway, she was required to give us this judgment, but she circumvented it. She made a material misrepresentation, a game changer, like I had never seen before or heard of before. It was like a mastermind plan to deprive us of everything, our life, liberty, and property. Her order, I have it here in front of me, 5-page order. This is the material misrepresentation that she entered. She said, I stated, though defendants could have been much clearer as to their desire for rescission and their attempts to rescind the contract, defendants are before the court pro se, and the court finds that defendants have made sufficient allegations in their counterclaims and arguments before the court to state a cause of action for rescission. Therefore, she came to the conclusion that she was going to grant us rescission of the construction contract. Now, on the last page, she goes on to say it is therefore ordered in a judge that final judgment is hereby entered against plaintiff on its complaint. That's Damron Construction Company. So Damron Construction Company has no right to any relief in equity or law. She entered judgment against his complaint. But she goes on to say that it is ordered in the judge that the construction contract is hereby rescinded and of no effect. She goes on to say, defendants are hereby ordered to pay Damron for the reasonable cost of materials and labor it supplied in the construction of the house. Now, ladies and gentlemen, this is an unlawful way of overturning or reversing Judge Strickland's finding based on a lie. The lie, remember, that Ron and Gloria Mickens could have been much clearer about what I desire in our attempts to rescind the contract. This is a lie. I just explained and told you all what our prayers was, what we had went to trial, the 5 claims that we had went to trial and prevailed upon. These was our 5 claims in our pleading. We did not invoke the court's jurisdiction for rescission. Rescission was not even available. We had a remedy in law on our fraud action. We had a remedy in law on our breach of construction contract action. So rescission can't even exist. It's unavailable. But this was fraud on the court. Now, let me read a couple more statements from her order. She says, finally, Damron fraudulently maintained a claim to fee simple title to defendant's property. I'm going to stop right there because let me repeat it again. Finally, Damron fraudulently maintained a claim to fee simple title to defendant's property and used that claim to gain in it an unfair advantage as to what materials and features would be included in the house. Another statement. Finally, Damron fraudulently obtained a quitclaim deed from defendants and attempted to use its improper claim to fee simple title as leverage to force defendants to accept features in their house that they did not want. Excuse me. Okay. But what I want to key in on, she said fraudulently maintain and fraudulently obtain. The deed is void. Ab initio. She adopted Judge Strickland's findings of fact. Damron had committed fraud in inducement, fraud in misrepresenting the nature of a deed, fraud in execution, fraud in the formation, performance of a construction contract. Now, let me ask you this question. Why would we give up a $100 million action in exchange to pay Damron Construction Company for the cost of materials and labor? Does that make any sense? This is a fraud. This is a conspiracy. You see how Judge Moore is using rescission to extricate Damron and its co-conspirators from their crimes. I filed case number 1998 CA-001152, where I joined all of these additional parties and claims. She dismissed it, said, now, your judgment is for rescission now. No, I filed another action, 1998 CA-002977. But this case a lawsuit went to Judge Prince. The Damron, Stewart Title of Polk, Canady, Rewis, all of them filed motion to dismiss, motion for summary judgment. Judge Prince rejected all of their motions to dismiss and motion for summary judgment. Ruled that all of our claims and causes of action was viable. They were undeniable because of Mrs. Canady fraud. He made it clear in that conference that Miss Canady was wearing all of these hats, had committed all of these egregious acts, and did it for a profit. It was fraud. But they hooked the judge by saying that there was 3 lawsuits on the record, and that all 3 of the lawsuits was identical. They was the same. They involved the same parties, the same issues. So the cases had to be consolidated down. Had to be consolidated down to the original case, which Judge Moore had, which was 1997 CA-000455. But when all 3 lawsuits got down to Judge Moore, just like she set aside the 1152 case, she set aside the 2977 case, saying that our judgment now was rescission. We said, no, we're not going anywhere near rescission of the construction contract. All 3 of our lawsuits shows and demonstrate what our desire and what we are attempting. But no, she gonna impose rescission without jurisdiction. Okay, so we don't have a choice. We have to appeal. We appeal, and Damron Construction lawyer, they file a cross appeal. So both parties appeal. Let me give you the gist about cross appeal. I could go on and on and on about how strongly we opposed rescission. But, since it's going on and on, I think you get the gist. But this is kind of sums up what our arguments was on appeal. We stated that based on race, Judge Moore, without jurisdictions, arbitrarily, capriciously, pretextually, outrageously, shockingly, maliciously, negligently, and fraudulently imposed her fraudulent, unavailable, unauthorized, unnoticed, unsought, unsolicited, undesired, unnecessary, inadequate, inappropriate, unlitigated findings objected to by both parties, rescission judgment. We strongly oppose it with everything that we had and all the know-how that we had. This didn't make any sense. This was theft. We were entitled to a judgment based on fraud, cancellation of the deed, not cancellation of the construction contract. We had breach of construction contract. You can't overturn the trial judge findings of facts and conclusions of law. They're protected by res judicata / claim preclusion and collateral estoppel. That's issue preclusion, meaning that the claims and the issues cannot be relitigated. The judge can't. Second District Court of Appeal couldn't do it. Couldn't overturn Judge Strickland's findings of facts and conclusions of law, his judgment on the merits of our 5 claims. That's impossible. You would have to go back and say that Ms. Canady, Rewis, Highsmith, Stewart Title Guaranty Company, Stewart Title of Polk, the Damrons, them did not fraudulently convey our property, did not fraudulently create this quick claim deed, did not fraudulently notarize and prepare, deliver this deed, did not fraudulently induce chase, did not slander our title, did not convert our title. Can't reverse those findings. You can't reverse their organized fraud, their schemes to the fraud, their forgery. Ms. Canady, Damron Construction Company couldn't have done any of this without Mrs. Canady. She was a title insurance agent, licensed. She was the issuing agent. I hope you're understanding and getting this. When you're the issuing agent, you can't dare issue a policy based on a fraudulent deed, knowing about it. That's malicious. It's intentional. It's egregious. And then you false notarize. You commit criminal felony acts on all 4 of the notary statutes. Then you're the closing agent. All of those are fraudulent acts. That has to be. She has to be held accountable for. You can't sweep it under the rug like the state attorney did, like Judge Strickland was doing. And now you got Judge Moore. Now, let me get back to that specific issue on cross appeal. And this is an excerpt from Damron Construction Company, a cross appeal of Judge Moore's rescission judgment. And I'm going to read it to you verbatim, pretty much. Judge Moore granted rescission based upon her finding that the Mickens were essentially seeking rescission, and that while the Mickens could have been much clearer as to their desire for rescission and their attempts to rescind the contract, the Mickens are before the court pro se, and the court finds that the Mickens have made sufficient allegations in their counterclaims and argument before this court to state a cause of action for rescission. Those findings are factually and legally incorrect. Those findings are factually and legally incorrect for a number of reasons. First, at the time the Mickens counterclaims were prepared and filed, as well as at the time their claims were tried to the court, the Mickens were represented by counsel. Neither the Mickens nor their counsel ever filed pleading seeking rescission of the construction contract. To the contrary, in count 5 of their counterclaim, the Mickens sought damages for the alleged breach of construction contract, while in count 2 of their counterclaim, they sought cancellation of the deed, but not the construction contract. To suggest or find that their pleadings effectively sought rescission ignores the plain and direct prayers for relief in the pleading filed by their counsel, and supplant those pleadings with the lower court's unsolicited evaluation. Second, Damron did not pray for rescission, and the Mickens have made it quite clear in their arguments before the lower court and their brief to this court that they did not seek and did not want rescission. Damron was never advised that the theory of rescission would be advanced, and accordingly never prepared to address such a theory. If Damron had any inkling such relief might be sought, it could have and would have sought leave to amend its affirmative defenses to include a defense that the Mickens had in fact ratified the contract by repeatedly moving into the home or occupying it for their own purposes. Okay. They went on to state that to grant such relief, when neither party sought the relief and neither was in any way put on notice that such relief might be granted, is plainly error. When an award of relief is not sought by the pleading, it is error to grant such relief. Granting relief neither requested, noticed, nor litigated by a party constitutes denial of due process. Moreover, the court has already ruled in the prior appeal of this very cause that it cannot affirm the award of relief sought by neither party. All of this case law that I just finished quoting. It said, thirdly, even if the Miggins had prayed for rescission, they would not be entitled to such relief since they had an adequate remedy at law under the breach of contract claim, which they in fact asserted. Also, fourthly, they said Judge Moore appears to have justified the award based upon her findings of some species of fraud on the part of Damron Construction Company. There's that word again, fraud. We have a fraud action in all three of the law suits that we filed. Fraud action not only against the Damrons, but also Stewart Title Guaranty Company, Stewart Title of Polk, Canady, Rewis, Highsmith. Those were the officers. Highsmith was the president, Canady was vice president, and Rewis was the treasurer. Engaged in all kinds of fraud. Even the company, Stewart Title Guaranty Company, had criminal action pending against them and civil action pending. Oh, but we don't want to go into that too much because they tried to keep that information hidden from us. Or the state attorney, or pretended like Canady and them wasn't engaged when he had criminal actions pending by Stewart Title Guaranty Company. Okay? But he was involved in this cover-up on behalf of Miss Canady, Rewis, and Highsmith. Or they had their reasons too for keeping this low profile too about Miss Canady and all of her misconduct, because Miss Canady was that centerpiece at Stewart Title of Polk. She was a licensed agent. She was the issuing agent. Critical position. It has to be the most trusted person in the organization. She's the issuing agent. She was the title closer. She was the notary public. You cannot, no, please understand, you cannot do what Miss Canady did in a title company. This is the worst of the worst. This is the heart. It's the heartbeat of the entire organization, the most trusted position that you could be in. And she committed the most egregious of them all. Totally unacceptable what she did. She has to be held accountable. But the state attorney have committed this pattern of cover-up, and the judges are following through with it. You saw it with Judge Strickland. Now you see it with Judge Moore. But listen, I just went over with you how both parties on appeal objected to rescission because of this lie. Rescission was like us committing a criminal act against ourselves. Why would we give up millions of dollars to pay the losing parties? People that had committed egregious act. Why would we agree to pay them in exchange for all the relief that we were entitled to? Why would we? Is that fair? Is that due process? Here I just read you a total of 20 claims altogether. In exchange for one claim that's going to penalize us, then put us in a position to where Stuart Title can so-called foreclose against us. I will get to that because I'm going to explain to you in details about all of this fraud upon the court. I'm just going to flash it at you. But all the rest of these orders that's in this file here that I have in front of me, you see all those tabs, those purple tabs, those are orders and judgments from the court. All fraud. all frivolous. Just a machinery. This was no longer a court. I guess I have to call it a kangaroo court manufactory that's producing fraud, lies. Not a place for justice anymore. But let me make sure that I cover this. And then I'm going to get into that next. But the main thing that's coming up was that the Second District Court of Appeal affirmed rescission. Now that's the shocker. It's unbelievable. Listen, that's why you got to stay tuned. When the Second District Court of Appeal affirmed rescission, we had no rights. That was a death sentence. That licensed the lower court to do anything they wanted to us, and they did. That's why I'm telling you about all these fraudulent orders. They created this machine to produce fabricated evidence, fraudulent evidence, to lynch us, arrest me and put me in jail, send a sheriff's SWAT team to deprive me of my life, liberty, property interests in my employment. There were no limits. When they affirmed rescission, that was like the law of the case now. When we filed our complaint in federal district court, they adopted rescission as being the law of the case, knowing all the time that Judge Strickland adjudicated findings was the law of the case, impossible to be reversed. But they said that they didn't have jurisdiction under Rooker-Feldman. Rooker-Feldman was obsolete. Then we had added constitutional and civil rights claims against the sheriff, the property appraiser, and the state attorney. Also, we had filed claims for fraud upon the court against the 10th Judicial Circuit and the Second District Court of Appeal. He said they didn't have jurisdiction. It's a lie. There ain't no statute of limitation on fraud upon the court. Let me say that again. There ain't no statute of limitation. You always have jurisdiction. Court can't turn down a claim and cause of action for fraud upon the court. The federal district court jurisdiction was ruled by ExxonMobil. That was the name of the case, which basically meant that as long as we submitted our complaint before the state court proceeding ended, they had jurisdiction. Also, I told you about how when you add additional claims and additional parties, additional issues, then you add constitutional and civil right claims, that also give the courts jurisdiction. But more important than anything else, when you allege fraud upon the court, the federal district court have jurisdiction. And guess what? And I'm going to tell you this, and I'm going to take a break. But when we file our actions against the Second District Court of Appeal and the 10th Judicial Circuit, federal district court dismissed our complaint before they filed a response. You had the Damrons and Stewart Title Guaranty Company, they filed motions to dismiss. So the federal district court jumped on that real quick and dismissed everything we filed with prejudice, because they knew that if they required the 10th Judicial Circuit judges and the Second District Court of Appeal judges respond to our fraud on the court action, they had jurisdiction. And then too, they ain't but one question. We could have easily asked the court for a declaratory justice, because what proves that we had the law of the case, that Judge Strickland's findings on the merits of our fraud, cancellation of the quiet title, ejectment, and breach of contract claims and cause of action was the law of the case. All we needed was to ask, were those findings reversed? They cannot be reversed. That means that we have a run of the table on all of our claims. Not them. They turn us into the bad guys, or they turn us into the losers and turn them into the winners. Now that's where I'm going to pick up, because I got some stories that you don't want to miss. Because like I told you, they created this machinery of lies. Oh, you hadn't seen anything like it. You could never fathom, I know I didn't, that our courts could be this corrupt. And it's for, ladies and gentlemen, you be the judge. I'm going to break it down. It's for the blood money. They were bought. So, I know you're going to be looking for the next episode. Until then, I'll talk to you later.